I actually think you dropped it on accident. You throw it on the ground.
I ain't throw nothing on the ground. I promise you I did.
This is a camera.
Okay, I didn't throw nothing on the ground. I promise. You didn't see me throw nothing.
Yes, I did. You got any coke?
No, I don't have none.
No, okay.
No, I just came to my sister's house.
She had coke on her, okay, so she's going to jail for that. It's because the coke she threw was right there in the grass.
On August 24th, 2023, Trooper Lucky of the Indiana State Police conducted a traffic stop that escalated through 4 distinct criminal charges before the encounter ended inside a hospital. This analysis examines the constitutional and statutory framework governing each phase: passenger detention, constructive drug possession, physical resistance, and battery on a law enforcement officer.
What's your name, ma'am?
Latanya.
Latanya, I'm Trooper Lucky with the Indiana State Police. He explained why we stopped you guys, right? Okay. Gotcha. I was just looking at this picture here and thought maybe it didn't quite look like you.
That's me.
What's the last 4 years? Okay, I appreciate you. We'll be right back with you.
Okay.
I'll have you come back here, okay? If you want to sit on the curb, you can.
I'm sure because I'll get stiff.
You what?
I'll get stiff. Be hard for me to get up.
Okay.
That's all.
Okay, you're good then.
I just got out of jail. Lake County. I just got out.
For what?
Failure to appear.
For what?
Probation.
Come on, face the car.
Why? Oh no, that's why.
Separating the passenger from the vehicle was lawful without additional justification. In Maryland versus Wilson, the Supreme Court held in 1997 that officers may order any passenger out of a vehicle during a lawful stop on officer safety grounds alone. That authority traces back to Pennsylvania versus Mims and requires no individualized suspicion. Latanya's spontaneous disclosure of a prior failure to appear in active probation status was fully admissible. Miranda versus Arizona applies only to custodial interrogation. A passenger detained roadside not yet under formal arrest who volunteers self-incriminating information has no Miranda protection over those statements.
I ain't got no warrants. I don't have no warrants. What's wrong?
Stop.
I don't have no warrants.
Stop. I'll talk to you in a second.
What is
Stop.
wrong? I ain't did nothing.
Okay.
No, I did. No, I did.
Let go.
I don't have anything. That wasn't me.
Hey, ma'am, if you resist me, I'm going to charge you with resisting arrest.
I'm sorry. That was not me. I promise I ain't
Stop
done
resisting
shit.
him.
That
Stop.
wasn't me. I haven't did anything. Please, sir, I
Stop.
haven't did anything.
We're not going anywhere until you calm down.
Okay, I haven't did anything.
If you calm down, I'll talk to you.
Okay, I haven't
Is that
done
fair?
anything.
Is that fair?
I haven't done anything.
All right,
I promise.
so right now I want you to relax your arms. Relax your arms. Okay, so don't tense up on me again, okay? I want you to spread your feet. Okay, and I want you to relax your arms. Okay? All right, just like this. Don't pull away from me again, okay? All right, let your arms go. Touch the back of your hands together. Ma'am.
Put the back of your hands together like this, okay? Yep, exactly. There you go.
I haven't did anything.
You're good. Okay, don't move. Okay? You're just being detained. We'll figure it out. Don't worry. You got any more on you?
No, that's not mine. That don't belong to me. That's not mine. I promise you that.
Stop moving.
That's not my I promise
I
you.
watched you throw it on the ground.
I ain't throw nothing on the ground. I promise you I did.
This is a camera.
Okay, I didn't throw nothing on the ground. I promise. You didn't see me throw nothing.
Yes, I did.
No, you didn't. You telling the story. You didn't hear me throw nothing. That was not mine. I stood right there. You didn't hear me throw nothing in the ground. If I thrown it, I would have thrown it in front of you.
I actually think you dropped it on accident, if I'm being
I
honest.
don't have nothing. I don't do that. Oh, my mama, that's not mine.
Hey, you got any coke?
No, I don't have none.
No, okay.
No, I just came to my sister's house.
She had coke on her, okay, so she's going to jail for that. Is there any more in the car?
No, I just picked her up. She just got in right there on 15.
Okay, who does the car belong to?
That's my car.
Okay. Can I search it?
Yeah, I don't have nothing in my car.
Okay. Just stay here for a second. The reason why I wanted you to sit over here, not on the curb, is because the coke she threw was right there in the grass. I just didn't want you near it, so that way there's no miscommunication. Okay?
The controlling legal issue is constructive possession under Indiana Code, Section 35, 48, 4, 6. The statute criminalizes knowing or intentional possession of cocaine as a level 6 felony at baseline, elevating to level 5 at 5 grams and level 4 at 10 grams. Indiana courts interpret possession to include both actual and constructive control. Constructive possession requires the state to prove the defendant had the intent and capability to maintain dominion and control over the contraband. Throwing cocaine out of a vehicle in direct view of an officer does not defeat that element, it establishes it. Under Illinois versus Cabela's, the observed discard also provided standalone probable cause for arrest and vehicle search, independent of the original DUI basis for the stop. From a defense standpoint, the constructive possession challenge collapses when the officer is a direct eyewitness to the discard. The argument that the narcotics belong to someone else fails against that testimony. The discard simultaneously confirmed possession and forfeited any Fourth Amendment suppression argument the defense would otherwise have raised. Physical resistance during the handcuffing sequence triggers Indiana Code Section 3544.131. Base resisting is a misdemeanor. It becomes a level 6 felony when the subject uses or threatens force. The Indiana Supreme Court clarified in Paquette versus State that only one resisting conviction may arise from a single continuous act, a relevant sentencing limitation if multiple counts are filed. The trooper's use of force is governed by Graham versus Connor, decided by the Supreme Court in 1989. Objective reasonableness is assessed from the officer's perspective at the moment, not in hindsight. The 3 Graham factors, crime severity, immediate threat, and active resistance, all favored escalation. Soft empty hand control progressing to head stabilization when a bite was alleged remains within the proportionate range under that standard.
Yeah. Okay, good deal.
I'm hot, sir.
I understand.
Please. That's not mine. Okay. That's not mine.
I appreciate it.
That's not mine, sir. That's not mine.
Can you move? Actually, I'll just go.
Oh, it's hot. Highlighters. I don't have any. That's a lighter. Mine. Where my phone at? That's not my stuff.
Your phone's in the purse.
Okay.
I'm giving you a chance to be honest before I search your purse. If there's more in here, I'm not willing to work with you. But if you're honest, I will work with you. I know I'm going to find some coke or something in there, so tell me what I'm going to find and I'll be honest, and I'll work with you.
That's not mine. They're going to lock me up.
Okay.
There's nothing in there. Some blood. There's nothing in there.
Okay.
Nothing. Nothing. That's not mine.
Do you have a medical condition we should know about, ma'am?
Yes,
What do you have?
I have failure heart. Congestive failure heart. Yes, I do.
Okay. Do you need to see a doctor right now?
Yes.
Yes?
Yes, I'm sweating bullets.
Do you want EMS to come here?
Yes.
Okay. Little 13-255.
That's
Passengers
don't belong
requesting
to
a
me,
1052.
That's not mine. Can I have my asthma, please?
I gotta tell the ambulance what.
That's not mine. That does not belong to me. See,
Hey, stop moving your arms when she's trying to search you.
I don't have anything.
Is she letting you search?
Yeah,
That's all I have is a lighter.
There.
That's it.
Yeah,
That's all I
this is all
have.
it is.
Nothing.
Is there more coke?
No.
Is that what you found?
Yeah.
No, he
Well, then
found
I'm
no
not
coke
opening
on me. He haven't found no drugs on me.
I did.
No, you did. You said I dropped something. I didn't drop nothing, sir. That's not mine.
To drive with her at this
That's not mine. You wrong. And then you say stuff was on his seat. That's not mine. I just got in the car with him. I promise you.
Have you taken vitals on her? No.
I promise
Because
you.
if she doesn't need to be transported by you, I can just transport her.
Yes, Amy. I want to the hospital. Just bring me my property. You got you wrong.
You okay if I take you to the hospital?
No, I want to go with them. Let just bring me my property, but you wrong. You accusing me of something.
I'll take that.
You
Put it with the other
wrong.
evidence.
That sounds nothing in the nothing. Nothing.
You can't go with us if she's gonna act like that.
Nothing. I'm just saying. He's talking about
Okay.
that. Okay.
Hey, listen to
Okay.
me. Listen to me.
Yeah, wrong. Bro. I will help you.
This officer right here is going to transport you to the hospital. Okay.
I'm gonna come jumping up there and say you wrong. You're accusing me,
Hey,
sir.
hey.
I don't have anything. That's not mine.
Listen.
That's not
gonna
mine.
transport you to the hospital, okay?
That's not mine.
Where was this at?
In my bra. I keep a lighter in my bra. I smoke cigarettes.
What's the paper towel?
My baby, look how I be sweating, sir. Ain't nothing in there, I promise you. I don't have no drugs. I didn't have no drugs, sir.
Okay.
That's
Come on, come with us.
I have a right to talk to a therapist. I want to talk to a therapist. Please, before you take me, let me talk to a therapist, please.
There's no therapist.
A psychiatrist, yes, they are. Yes, they are.
Stop screaming.
Please, I'm not doing anything wrong.
People in this hospital are sick, and you're keeping
I'm
them
sick, but y'all don't care nothing about me being
People in this
sick.
hospital are literally dying. and you're
Okay,
screaming
I'm
people
dying
away.
too.
You're not dying.
I got heart failure.
You're perfectly fine.
No, that's what they're saying.
They're perfectly
They'll
fine.
tell y'all anything. I want to talk to a psychiatrist.
Okay.
I need to talk to a psychiatrist. So you're going to treat that base or whatever on me. And I want to talk to a psychiatrist. I want to talk to a psychiatrist.
Keep your arms down.
I want to talk to a psychiatrist.
Keep your arms down, okay?
I want to talk to a psychiatrist.
There's kids in the hospital.
Okay,
Keep your arms down.
Talk to the psychiatrist. I want to talk to a psychiatrist. Please talk to a therapist. Please. For 1 minute, can I talk to a therapist?
Stand up.
I want to talk to a therapist.
She just keeps putting them down.
I want to talk to a psychiatrist.
We're just gonna have to force her up.
Oh, now you got crazy. My brains are real gonna be stop.
Stop.
For real, I want to talk to a therapist. Can I talk to the therapist? It's a psychiatrist here. A psychiatrist.
Stand up.
It's a psychiatrist. I want to talk to a psychiatrist. I want to talk to a psychiatrist. You gotta have my hands out. I want to talk to a therapist. Let me pull my phone.
Stop it.
Please let me pull my phone.
Just walk.
Let me pull my phone. You hate me. You hate me. You hate me. You're abusing me. You're abusing me. You're abusing me. Yeah, you hurt me.
All right, come on.
You hurt me. I was sorry. I have a right to talk to a counselor, please. I have a right. I have a right. I have a right. I have a right. Wait a minute. I have a right.
Hey, she's bit me.
I didn't bite you.
Stop.
I have a
Stop.
right. I didn't bite you.
Yes,
I have
you
a
did.
right. I did not bite
Hey.
you. I did not bite you. I have a right to talk to a therapist. I have a right.
I don't think you went through the glove. She
I
tried.
didn't bite you.
Stop.
I have a right to talk to a therapist. And I'm not feeling good. Y'all can force me out here. I have a right. I have a right. I have a right. I have a right.
Just bit me.
I did not bite you.
Can you contact Maryville for a cage guard, please? I'm telephone.
Y'all wrong. I did nothing wrong. I want to talk to a therapist. I did nothing wrong. And y'all come in here and tell me I'm fine.
Stop.
I'm just doing this. I'm not going nowhere. You tell me I'm fine. And I'm not fine. I'm not fine, sir. I'm not. Please understand, I'm not fine.
Stop moving your head.
Again.
Stop.
Why? Why?
Because you're biting.
Why? I'm not
Stop
biting.
moving your
I'm
head.
not biting you. Take your hand off of my head. Take your hand off of my head. Please. Please take your hand off of my head. You ain't gonna take me like
Hey,
that.
don't bite then.
I want you to not get off of me like that.
Okay, don't bite.
You can't treat me like I'm a dog. Quit doing that. That's what y'all police do. Quit treating me like I'm a fucking dog. I am sick and y'all don't give a fuck. I want to talk to a psychiatrist. Y'all don't give a fuck. That's what y'all do to black people. Treat us like shit. Everywhere we go, y'all treat us like shit. Every time the police get involved, it's about shit.
The biting allegation introduces Indiana Code Section 3544.126, battery on a law enforcement officer, a level 6 felony. At minimum, it elevates to level 5 if the contact results in bodily injury. A, bite that breaks, skin meets that threshold. The evidentiary outcome depends entirely on injury photographs and camera footage, not on the on-camera denial, which creates a factual dispute but does not neutralize physical evidence. At the hospital, LaTanya demanded access to a psychiatrist. No constitutional Provision guarantees immediate access to a mental health professional during custody processing. The operative standard is Estelle versus Gamble from 1976. Deliberate indifference to serious medical needs constitutes an Eighth Amendment violation. The trooper's EMS call-out and hospital transport satisfied that obligation. When LaTonya verbally invoked her right to an attorney, the trooper ordered transport rather than continuing, questioning the correct response under Miranda. Trooper Lucky receives a B+. The stop, separation, EMS call-out, and use of force continuum were all legally defensible. De-escalation was verbalized before each physical escalation, and no weapons were deployed despite active resistance, and a biting allegation. 2 procedural gaps prevent a higher grade: transporting by patrol vehicle despite a credible cardiac complaint, and absence of a clearly audible Miranda advisement in available footage prior to formal arrest. LaTonya receives a C. The cocaine discard was the single most legally destructive act of the encounter. It confirmed possession and eliminated most viable suppression arguments simultaneously. Each subsequent choice compounded the exposure. Resistance added a felony charge. The bite allegation added a potential level 5 charge. Silence and physical compliance after the initial stop would have preserved every legal remedy available to her. The driver receives a B. Cooperation was appropriate throughout, but consenting to a vehicle search while a passenger was detained for narcotics possession surrendered a meaningful Fourth Amendment challenge without evidentiary benefit. First takeaway: discarding contraband in plain view does not defeat possession, it proves it. The observed discard satisfies the dominion and control element of constructive possession and forfeits the suppression argument that would have been the defense's strongest avenue. Second, resistance during a lawful detention is never legally neutral. Every act of non-compliance is independently chargeable. Compliance under protest, followed by a legal challenge in court, is always the superior strategic choice. Third, once a battery allegation is documented on Bodycam, a verbal denial is not a defense. The outcome belongs to physical evidence, photographs, medical records, and camera footage. That evidentiary record is established at the scene, not in the courtroom. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.